The case of Mian Muhammad Nawaz Sharif versus the President of Pakistan is part of Pakistan's tumultuous political history from the 1990s. By way of background, it is important to know that on 17 April 1993, the Prime Minister addressed the nation. He told them that there were certain elements, which included the President, who were working against him and to destabilize his government. However, he vowed that he would not resign. On 18 April 1993, the President then passed an order where he used his powers under Article 58(2)(b of the Constitution of Pakistan. He dissolved the National Assembly, and various grounds for this dissolution were given. These included allegations of corruption, maladministration, and mass resignations from the National Assembly. A caretaker government was immediately sworn in. This dissolution was then challenged by Nawaz Sharif in the Supreme Court, and he brought a petition under Article 184(3) of the Constitution of Pakistan. Now, Article 184 empowers the Supreme Court to pass an order on an issue concerning public importance in relation to one of the fundamental rights guaranteed in the Constitution. There were two substantive issues before the Supreme Court. The first was whether the petition under Article 184(3) was maintainable or not. The petition would only be maintainable if a fundamental right was engaged in the first place. Now, the right that was allegedly violated in this case was the Article 17 right to form and be a member of a political party. Counsel for the respondents, which included the President, alleged that Article 17 was not engaged in this case at all. The second substantive issue before the Supreme Court was whether the President had exercised his powers under Article 58(2)(b in a lawful manner. By a majority of 10 to 1, the Supreme Court decided in favor of the petitioner. On the first issue, it was held that Article 184(3) did apply to this case. Article 17 allows you to form and become a member of a political party. The whole purpose of this right is to allow you to contest in elections under the banner of the party and then form a government if you have the requisite majority. This right would be meaningless if you were not allowed to continue your tenure in government once you did form a government. Therefore, the right to remain in government did fall within the ambit of Article 17, because of which a petition under Article 184(3) could be brought. On the second issue of Article 58(2)(b, the Supreme Court decided that the President had not exercised his powers under Article 58(2)(b within the parameters envisaged by the Constitution. The only way that Article 58(2)(b allowed the President to dissolve the National Assembly was if it had lost the confidence of the people and there was a complete breakdown in government. Now, the only way that the President could actually have decided that the Prime Minister no longer demanded the confidence of the public was by holding a vote of no confidence. Since no such vote was held, the President could not have dissolved the National Assembly. Mass resignations from the National Assembly was a common occurrence, and this was not a strong enough ground to completely dissolve Parliament. In a lone dissenting note, Justice Sajjad Ali Shah, however, disagreed with the reasoning of the majority on both issues. According to him, a petition under Article 184(3) was not maintainable. He believed that Article 17 allowed you to become a part of a political party. However, this right ended in the process of the election. The right to stay in government was not guaranteed by Article 17. The correct way for the petitioner would have been to bring a petition under Article 199 of the Constitution before the High Court. Therefore, the petitioner had chosen the wrong forum. On the issue of Article 58(2)(b, Justice Sajjad Ali Shah did believe that the President had exercised his powers in accordance with the Constitution. The fact that numerous members had resigned from the National Assembly and the Cabinet showed that their constituencies no longer trusted the government to run the country. This was indicative of a complete breakdown of confidence and trust. Moreover, the address of the Prime Minister on 17 April, in which he blamed the President for working against him, was also proof of the fact that the two pillars of the government were no longer able to work together. If this was not a ground for dissolving the National Assembly, then perhaps nothing else could satisfy Article 58(2)(b. This case falls on that side of the fence where the dissolution of the Assembly was declared illegal. It also shows that the Supreme Court was able to interpret Article 17 and 184(3) of the Constitution in a wide enough manner to put this case within the ambit of those articles. This shows their willingness to maintain a democratic government where it was possible to do so.